Life is complex, so is our mental health. It cannot be understood by diagnosis alone. Our philosophy is treat the person, not the mental illness. Hello everyone, and welcome to another episode of Humanizing Mental Health. I'm Trent Nickers.
And I'm Jeremy Alcorn.
Now we have a very special guest with us, don't we, Jeremy?
Yeah. So this one is going to be a little different than other episodes because this is the first time that we've had a lawyer on the show.
Yeah.
And I'm so fascinated because today I have two of the most brilliant people that I know actually that are going to be talking with us.
Oh, well, thank you. And I take it you're talking about yourself and our guest?
You are funny, man. See, Darren and Trent, there's times that we're having a conversation with them, and then they use a word, and I'm like, I have no idea what that means. And I sit there for a second, not wanting to seem like I don't know what I'm doing, and I'm thinking maybe I could use the rest of the context of the sentence to figure out what they said.
You're puzzling till your puzzler was sore.
Yeah.
And I think what we're going to be talking about today is actually language, is it not?
Yeah, it's actually a redefinition, that's for sure. So to start with, why don't we allow our guest, Darren, to give a little introduction to himself.
Hi, guys. Thanks for having me on. So I am a family law lawyer here in Medicine Hat. I've practiced for about 12 years, mostly in family law, but I've done a little bit of a mixed bag. And I have found it challenging and interesting and infuriating and exciting all at the same time. So there's lots of ups and downs, and probably the downs are mostly caused by, I guess, our topic today. So.
Oh, sure, yeah. In fact, to kind of set this up a little bit, Darren and I go to church together, and we started to have this conversation about some redefinition of law, and it reminded me of something from almost 20 years ago. So when I was at the Calgary Counseling Center, I worked in the Homefront program, which is for domestic violence. And we had to get several pieces of training to be able to do that. And in one of them, they were defining what abuse is, what violence is. And so they had this big spectrum that they had across this whiteboard, and they were saying, we want you to place in order what is the most damaging kind of abuse. And everyone agreed that physical was on the far side, that was one of the most damaging. And then, but there's lots of different types of abuse: financial abuse, emotional abuse, a variety of ways that people actually harm and try to control another person. And so then at the end, it was a trick. They're like, well, actually, all of these are violence. And I sat with that going, no, violence is when you hit somebody. And like, while all of those other things are bad, they're not violence. Well, in terms of the mental health world, violence has been identified as any form of control for a very long time. But that's not how it has been set up in the law. And I think that's where our conversation takes us.
Yeah, I think I'm like you, Jeremy. I struggled and probably still struggle to equate violence in terms of an assault or a battery with violence that's caused by words or actions of others. But I think what they're focusing in is on the impact on the individual, as opposed to what we can see or what manifests in terms of injuries or sort of the immediate experience of somebody who's been abused. But yeah.
Can you tell us about like what the wordage is, how that has changed?
Yeah, so since 1985, when the federal legislation about divorce came into force, there wasn't a definition about family violence or domestic violence in that act. And so in about 2021, when several amendments came into force, but the one we're talking about today is including a definition of family violence. And in the definition, there's actually this term coercive control that I wasn't really familiar with prior to the change coming in, but I've learned a lot about in the last little while.
Yeah. And I'm sure you're going to define that. But I have a question, but I don't want to interrupt you there, Darren. Yeah. What I almost wonder is, what brought about this change? Because it sounds like it's been something long-standing. Why now?
Well, I can speculate based on my own experience, but I think that because there is interwoven in family law and divorces, all of these dynamics where abuse seems to be a main factor in many divorce or family breakdowns, that they want to make sure that it's part of what judges consider when they're looking at the impacts of people's individual situations in their divorce or breakdowns of their relationships. I should maybe clarify that this change has only been put into the Divorce Act. There are other definitions and other pieces of legislation that speak more to relationships of we'll call them adult interdependent partners, or intimate partners, I guess, is sometimes the wordage that's used, and those are two different things as well. But we can get into that more. But as of right now, the inclusion of coercive control as a type of family violence has only been codified in the Divorce Act.
That's actually very important.
Yeah.
Because it doesn't look like that necessarily in criminal law. Do you know what the definition is in criminal law?
No, I practice no criminal law whatsoever, and I should be more interested in it.
And you know, like I'm wondering, like, as I think about this, because if that definition is just in family law, like, how does that change your ability to practice? Or if you have like, is this going to be something that is almost like a test bed and then eventually brought out into other areas? And how will that change things?
It is an interesting thought, isn't it?
Yeah, and I think you're right on. I think that, there's, as the federal legislation goes, I think the provinces tend to follow. And so, for example, what we've seen, this is an example that doesn't touch exactly on family violence, but a big problem, we'll say, in family law has been that of what we call mobility. It's when a parent moves the children away from the other parent, and so the amendments that happened to the Divorce Act that also included the definition of family violence included some provisions about what requirements somebody has to meet in order to be able to relocate with a child away from the child's other parent, because it was becoming a main problem, and judges were a little bit all over the map in how they dealt with that problem. And so what followed is that even though that change is not codified in the Family Law Act, which is the provincial legislation that governs family relationships, provincial judges in the province of Alberta started to use sort of the definition and the criteria around mobility. And so I think we're starting to see that as well with the new definition being included in the Divorce Act, is that judges are looking at that and saying, well, this may not be in the legislation that I'm required to consider right now, but I'm going to still consider it.
Yeah, and like when you bring that up, it makes me think of some people that I've worked with before, like where their parents and the family is breaking up, and they have really struggled with me on a mental health aspect of how do I move my kids, how do I maintain my family, how do I have that consistency for my child when I'm trying to navigate this legal jungle, because like you said, it can be different on all levels. So in some ways, it sounds like this is going to streamline the process, make it easier for yourself, and maybe even easier for the clients to understand and navigate.
And probably maybe even muddy in some ways too.
Yeah.
It might muddy the waters in some ways.
Yeah, it certainly adds it's another layer of complexity, something new to consider. But when I'm advising clients, it brings it into the conversation more. In part of the process of commencing a divorce is you file a claim with the courts. And when the new legislation came in, the form that we use for the claim changed so that now parties have to sign a declaration saying whether they've disclosed all other court proceedings, whether they be criminal, whether they be family protection, whether there has been family violence, and then I, as their lawyer, sign something saying that I've fulfilled all my obligations to them to consider these things, to consider, or to advise them rather on keeping children away from parental conflict and protecting them from any of the negative things that arise from that.
Sure.
I wonder how this impacts things from a trauma lens.
Yeah.
Yeah.
Mm-hmm. Like one of the things that really jumps out at me as we talk about this is the interconnection that we have between mental health and our legal systems. Because I think that, you can tell me if I'm wrong, but massive changes have happened over the last about 15 years in terms of family law as it comes to divorce. Parent alienation, children having access to both parents recognized as in the best interest of the child, even judges designating a voice of the child lawyer for the child in processes. So this has been a part of a big stream of changes that have happened because of an understanding of the health impacts. Now, I say that very intentionally because when you look at in context, I used to supervise the Children of Divorce program in Calgary. So when you look at long-term outcomes for kids, there's some huge, not just mental health, but physical health aspects. The likelihood of developing an autoimmune disorder, the likelihood of developing asthma, there's a whole stream of social determinants of health that are associated with this. Even actually lifespan is something that is influenced. I say not predicted, of course. But what they're really finding is that it's not the divorce that harms the child, it's the conflict. Do I got that right?
Well, I think you probably have more expertise on that than I, but that's how we discuss it when I'm speaking to clients, when I'm speaking to judges, is that a healthy separation of parents includes insulating children from conflict, and we know that conflict has such negative impacts on kids, and I think it's demonstrated through a wide variety of negative outcomes for kids who have been routinely exposed to conflict in their homes. So yeah, I think you're absolutely right.
So if a kid sees their parents in this toxic process, then it undermines their own sense of security and attachment and their ability to relate with other human beings, actually, because that's the model through which they learn. So that's really important. Now, I'm also wondering, because I think there's actually a massive crossover in terms of what we do on a day-to-day basis. The intent a little bit is different, but there's a reason that your title is also advocate.
Right.
And so there's got to actually be a lot of information as a lawyer that informs the law that is associated with research from the mental health field.
Yeah, and I think there's been, when you talk about there having been changes in the law or the way that we approach sort of family dynamics in the law, you're absolutely right. There's been a lot more recognition, acknowledgement of the impacts of conflict on children, the impacts of or naming and identifying parental alienation, refuse dynamics between children and parents. So I think we've moved. And I've been practicing for 12 years, so all these changes maybe happened early in my career, and so I was in them and didn't really notice them. But as I look back and read old cases and stuff, I think it's more part of the conversation.
And it almost maybe sometimes you're like, wow, this seems medieval.
Yeah.
Yeah. If you go back too far, you can be like, why didn't they talk about this?
Yeah. Or why was society organized this way at all?
Yeah.
That's
right.
I'm just even imagining going back into the 50s and 60s where it was even hard to get a divorce in some cases.
Right.
Where it was almost on the burden of the woman or the individual that was looking for the divorce to actually prove that.
Yeah, right now grounds for divorce are separation for 1 year, or adultery or mental emotional cruelty.
So they don't use the word abuse?
No. But I think, maybe sometimes we use them interchangeably, but in the legislation itself, no.
I think that is important because the people don't find that word palatable. Yeah. They're just like, what? No, I'm not a villain. I'm not a horrible human being. You're calling me a horrible human being, and I won't accept it. And then it just fuels a fight.
Right.
Yeah. So I'm curious, how often when you're working with clients, do you look at them and say, I think it's time maybe you need to see a counselor for support about this stuff like this?
Constantly. I don't know that there's anybody that comes in where I'm like, I don't express to them they should go talk to somebody, just because they're going through one of the most traumatic things in their life if they're having a breakdown of an intimate relationship. And sometimes they expect me to wear that hat of counselor, and they want to vent things at me and express emotional turmoil they're going through, and I feel like I'm I can lend them a good ear, but not at $400 an hour. Maybe they ought to go talk to somebody who's got some expertise. Mm-hmm. So I'm constantly, I've got a list of names, and Jeremy, you're on that list, and Trent, you're on it now too.
Excellent.
Welcome to the list.
Thank you.
Welcome to the jungle.
Yeah.
We got fun and games.
Yeah.
But I think just going back, I think maybe definitions are important. We've been talking about coercive control, and there's always a definition, or almost always a definition section of any legislation, but they're always long and probably difficult for me to regurgitate. So the way that I think about coercive control is any pattern of behavior that dominates another person and sort of takes away their ability to exercise their own agency or ability to choose. And so that can be things like stalking. It can be actual physical violence or threats of violence. It can be patterns of controlling behavior, like controlling somebody's social media use to an extreme extent, controlling their ability to communicate with other loved ones. There's a whole array of things. But any time that someone has been controlled by another person over sort of patterns of behavior, that falls within definition of coercive control.
No, the only thing is, it is then your responsibility to demonstrate evidence that indicates that's true. So
that's the trick. Yeah. That's the continual frustration of lawyers, is because I don't know how much you want me to get into the legal process, but typically most people, their first instance in front of a judge in the family law process is in a forum called family law chambers. That's at least there's levels of court. That's in the Court of King's Bench. If you go to the Court of Justice, formerly known as the Provincial Court of Alberta, you would be in what's called family court, which is another type of docket court. And by docket court, I mean you're there on a list of other people, all they're wanting some of the judge's time, and that judge gives you 10 minutes per side to make your case, and all the evidence that you show up with is an affidavit, written evidence. And if it's not in that affidavit, it's not evidence that you can rely on. They don't want people going off base and throwing out all sorts of accusations that the other party can't answer. So in order to have sort of a fair process, both parties typically have to be able to give their affidavit evidence. Sure. And guess what? Actually, they're always opposite of each other.
And you share it with the other lawyer before you get there.
Yeah. You have lots of opportunity to review it and to be able to know what the other party's side is saying. And so whenever there's an allegation of family violence, there is always a denial, almost always. I've had very rare circumstances in my career where it's been acknowledged.
They're like, yeah. I was pretty well a schmuck in that situation. Yeah, I did that.
That's right. But most of the time it's denied. And then a judge is sitting there thinking, well, I don't know either of you from a hole in the ground. And so unless there's something else that is patently obvious that one person's accusations are correct and the others are not, it's just he said, she said.
And sometimes now he said, or she said, she said.
Yeah. And everything in between. Yeah.
Yeah. And I almost wonder with that, like, what is it like to, because I can imagine for something like that, it's building up your client so that they're able to go through that process, even if it's just 10 minutes. And if it can go back and forth, it can almost be wearing. And how do you support that person going through that process where they're almost like, I'm just going to pull back and I'm just going to forget about this and let's move on?
Right. It's a good point. And I've had many long conversations with upset clients saying, we didn't get a chance to fully tell my story. And I have to say, that's not what this is for. This is a Band-Aid. Because a lot of people, I guess a statistic, I'm not sure if this is still the case, but in law school, I remember us talking about probably 97% of all matters that litigation is started on, including divorce matters, don't ever see a trial. And that's where the full story comes out, where they say, bring all your evidence, bring your witnesses, bring your documents, put them into evidence. The judge will hear all of it, and then they'll make a decision based on the totality of the circumstances. That doesn't happen for months and even years. And so a lot of times people feel like they've not had their day in court, and it's a difficulty because to pay a lawyer to run a trial for you can cost upwards of $10,000 a day, and if you need a week of trial, then that's not attainable for most people.
Yeah, for a lot of people, sure.
So there's other processes that are being engaged increasingly that sort of take things out of this adversarial process of litigation and put it into something that's more collaborative, or where we say, let's set aside all of the allegations and accusations and let's just talk about solutions. And that we refer to those as alternative dispute resolution, or ADR processes. And they can take all sorts of forms. But if you are actually a victim of coercive control or domestic or family violence,
then we're like, let's collaborate with your person that has been abusive with you.
Right. Yeah.
So let's do that. Let's collaborate with this bully. That's going to work out really well.
Absolutely. And I mean, like, let's talk about, re-traumatizing or further traumatizing. I could only imagine what it would be like for that person sitting in that room potentially, or having to say to you as their advocate or as their lawyer, go and make peace with the person that has been, traumatizing me or trying to control me for months or maybe even years.
Yeah, and I think one of the big pieces there is about this individual that potentially has been a victim of this just wants to have a balanced, fair process a lot of times in the divorce, and they know that the other person's not going to be willing to do that. So then you get into like a litigation terrorism.
Right. And I mean, if you have somebody there's been a pattern of controlling behavior, they're not gonna let go of that. And so I found that as I have represented people that have been victims of coercive control or family violence, that suddenly all of the control that was focused on their former partner now focuses on me. And so they'll do things like message their former partner if they're allowed. I mean, sometimes there's criminal charges where there's
no contact,
but if they're allowed to have contact with them, one of the main tactics I've seen of people that have controlling tendencies is to undermine their ex-partner's confidence in their lawyer. And so they'll send them messages and give them phone calls, be like, I think this guy's an idiot. He's not serving you well. Like they really take offense to the fact that somebody is now standing up for
that someone has power.
Yeah. So, and that's one of the hardest parts of my job, is dealing with folks that have now zeroed in on me as somebody that stands in their way, and that they'll do anything to get me out of the picture, including making complaints to my professional governing body.
Which has happened?
Yep, absolutely.
I hadn't considered that.
Yeah, well, and here's the thing is that I'm sure that all of those complaints have to be investigated or have to be. So how do you say to yourself or approach that and saying that, is this a specious claim? Like, where is this coming from?
Yeah, and I can speak a little bit to the Law Society's practices, but they have sort of a early intervention process where they'll say, okay, let's hear both sides of the story, and we'll see if there's any merit, and we'll see if someone's actually been wronged by the lawyer, if there's been steps taken to mitigate or make that right. And but if like you say, if it's specious and it's obvious, there's early dismissals, and I've seen lots of those happen where somebody's just upset with me because I've stood up for somebody that they want to control, and it usually is obvious, and without much investigation, they can dismiss those claims.
Yeah. So it sounds like in your job, you have to wear this hat of being very compassionate for your client, but then also have a lot of thick skin to be able to go through this.
Yeah, thick skin's a good term. I don't want it to sound like my whole role is sort of this combative adversarial role. That is where it has to go sometimes.
Yeah, in this particular kind of case, when an individual has experienced coercive control, then sometimes you don't have any choice.
Right.
Like even in my office, people trying to get some guidance about what to do in their life in a situation, sometimes I'm like, it sounds like the only option here is to get a lawyer.
Yeah, I've had to say that a couple times too myself.
Mm-hmm.
But I would love for my practice just to mediate disagreements between two reasonable parties, and I do quite a bit of that, and I really enjoy it. But sometimes, you have to take on the adversarial role and go and for these types of people that engage in controlling behavior, authority is really the only thing they understand sometimes.
So, and maybe this is pivoting this conversation slightly, but I wouldn't be a good counselor or a good social worker if I didn't ask this. With that in mind, what do you do for self-care?
Well, I think there's increasingly talk about self-care for lawyers, and I think we've acknowledged within sort of our I actually just read an email from our professional governing body sort of about self-care and about taking care of your mental health, and how lawyers are notoriously bad at it. And so, I don't have a good answer for you besides I have a great relationship with a wonderful wife, and I've got kids, and I've got community involvement, and I've got church involvement, and I have things that I direct my energy into that is really healthy for me. But maybe I should be booking an appointment after this podcast over. That's
maybe. But like with Jeremy and myself, I don't know if that would be considered appropriate, because that would almost be a dual relationship.
We'd have to give you a name to somebody else.
Yeah, absolutely.
But so as you talk about self-care, how's your outside shot?
It's getting worse, I think, with age.
We used to get up at like 6 a.m. to play basketball together.
Yeah. Okay, now I want to do is watch you two play a little one-on-one.
No.
Okay.
Like what do you got on me? 6 inches of height?
I don't know. I haven't.
I'm pretty sure.
Jerry's got a pretty mean jumper. He's got a good mid-range jumper. I've seen it in person.
Yeah. So you don't just like to battle in the courtroom; you like to battle on the court.
Yeah. I get together with a group of old guys every so often and play basketball. And
it has come to that point in life.
That's right.
That we're the old guys. So one of the things that I wonder about, and that is, we've been talking as if the only people that you see are the people that are the victim of the control. I'm sure that is not actually the case. That sometimes you're like, oh man, I have the bad guy in this situation, but I actually still have to represent them. I have to represent them well.
Yeah, there's a British sketch comedy show where there's a couple of Nazi officers sitting around a campfire, and then they look at each other. They're like, we have a skull on our uniform. Are we the bad guys? Are we the baddies? I think they say. So yeah, I've had that conversation with clients before where I say to them, listen, you need to maybe go talk to somebody. You need to back off on these actions that you're taking. It's a difficult one, because I think the people who have these tendencies are the hardest ones to tell that they have them, because they won't necessarily acknowledge it when I say it. And I don't think I've ever sat down with somebody and said, I think you have narcissistic traits.
Mm-hmm.
I think I've never said that to someone, but I have said, maybe your unwillingness to let go of this issue that's not the issue. Sometimes the issue is not the issue, right? Or many times the issue is not the issue. So I say, maybe go talk to somebody about your unwillingness to let go of control of this aspect of the other person's life, or your unwillingness to listen to your teenage kids when they're telling you this, that, or the other, or so. But yeah, I'm certainly not qualified to diagnose anybody, but when I do see some of those things, I give that advice. It's very seldom listened to. I mean, sometimes they'll change their immediate behavior because they think it's a tactical advantage to do so, right? But nobody's like, oh, thank you so much. I went and talked to a counselor. And
I looked in the mirror and went, holy cow, I have been the bad guy.
That's right. Yeah.
I do see the skull. So, I'm wondering in that case, like, how do you say to yourself, I'm going to provide this person a vigorous defense?
Right. I've had a number of cases where I've terminated the lawyer-client relationship because I basically said, you're not listening to my advice and you're continuing a pattern of behavior that I think is destructive to your case. I think in the cases where they are willing to listen to my advice, at least temporarily, then, I show up and I do my best. I present the facts to the court based on what my clients told me and make submissions based on what the law says about that particular set of facts, and that's all I can do.
Yeah, in fact, the number of times that someone has talked to me and I went, man, it seems like a lawyer is the right process here. And they said, well, do you know anyone? And the number of times I said, well, I think you should go see Darren. The reason is because if you're just going to go look for a shark that is just going to battle and bash as hard as they can, well, one, it's going to be damaging to people in that process, the children and so forth. But the other is, I don't think it's often in the best interest of the person. That it's just they're just going to get deeper and deeper into this conflict without resolution, and they'll spend way more money. And so I'm like, I know that if you talk to Darren, he's going to have a balanced idea or view about this. He'll give you a frank feedback about when it's time to push and when it's time to maybe be flexible.
Mm-hmm. Well, thanks. I appreciate your confidence. I do explore first before litigation. I explore sort of everything else to make sure they know what else is on the table. And sometimes the best way to express it is in dollars and cents, because say, well, we could fight tooth and nail all the way to the end and push for a trial, and here's how much it'll cost, and it's usually a 5 to 6 figure amount. Or we can try and sit down and discuss things like civilized people, and at the end of that, you can have a solution that you've had a part in framing, rather than putting the decision-making power in a judge's hands.
And I can imagine that them having that role in that solution-making process, not only would it have more positive effects for them in terms of having a resolution, but it would also maybe have a more positive effect on their overall mental health.
Yeah, I would expect so. I can't speak to the mental health part, but I can speculate that absolutely.
Oh, but I imagine you've actually seen things.
Mm-hmm.
Like you sit there and you see it happen. You see it happen in front of you, and you know what is happening. Even if you're not a mental health professional, that you're a human being.
Mm-hmm.
So
yeah, a story that comes to mind is when I was a fairly young lawyer, I helped with a case that was between two very high conflict individuals. And they would fight over the color of the sky, or any subject you put in front of them, they would find a way to fight over it. And I remember as a young associate at a law firm, I worked on the case. I even went to court and argued the case. And I think the thing I argued was over, whether a parent could take their kids to Disneyland or not, because one of the parents wanted to go and the other didn't. And we showed up and the judge said, "Are you serious? You're going to say no to Disneyland? Do you want to be that parent?"
Tell me you were on the yes side of that.
I wish I could say that. So, I was giving advice to...
You were on the no side.
Yeah. Sometimes
Wow.
you show up and you you do what you're told.
Oh, I got to stand up and say this. The judge looks.
This is where
why did
the
this
old
come in front of
philosophy
me?
degree comes in handy, where you're able to argue the opposite side that you may not agree with.
Yeah. So I'll finish my story in a sec, but that reminds me of a lawyer joke. Can I tell a quick? Okay.
Shoot.
So a lady goes in and talks to first a teacher, then an accountant, then a lawyer, and ask them all the same question. First the teacher, what's 2 plus 2? Teacher, 4. The accountant, what's 2 plus 2? And the accountant says, let me just run it through my spreadsheet. I'll give you an answer. It's probably either 3 or 4. Mm-hmm. And then she goes into the lawyer, and the lawyer looks around. draws the blinds down, closes the door, and says, "What do you want the answer to be?"
I like it.
But the end of that story is I ran into this man who had been the client of my former firm, and we had kids playing sports together. And I saw him sitting near his ex, sitting beside his ex, and they're laughing and very friendly with each other.
Oh.
And I went and talked to him after. I said, "What happened? I don't think I ever imagined a scenario in which you could be friendly with your ex." And he said, "We got the lawyers out of the picture and just started talking to each other."
Ooh. So you know what? That's an interesting statement there, because sometimes you almost wonder to yourself, because there's been times you've said that you've fired clients, but have there been times when you've been said to them, maybe you need to take this out of the legal arena and just back into the human one?
Absolutely. We do that fairly frequently. I don't know if we completely push lawyers out of the picture, because sometimes I don't trust my clients to go in on a one-on-one situation and be able to be rational and reasonable and compassionate and graceful to the other person. But what we'll often do is we'll say, "Hey, let's have a sit down with everybody. Let's just sit around. It's a round table." And at the beginning of every meeting, I say, "Here's the rules. We talk respectfully. We don't dwell on the past. We don't dwell on accusations or allegations of things that have happened. Let's talk about what's going to make your lives better. Let's talk about solutions." And when you put people in that frame of mind, and the lawyers are cooperative in promoting that frame of mind, I've seen really productive things happen. And some of my favorite experience as a lawyer has been to talk people through their own solutions and their own outcomes.
Ooh,
That sounds like us.
Yeah, I know. As he's talking, I remember when you were supervising me, we were talking about basically couples therapy, and it's all about what is the common definition of the problem.
Yeah,
Can we
yeah.
come to that?
Sure.
And I'm like, okay, you're basically working as a family therapist.
Yeah, we wear lots of hats, and,
Yeah.
and sometimes we're not qualified to wear some of the hats that
Well,
we're
but you don't always need to be a therapist to be therapeutic.
Beautiful.
I like that. I do a lot of child representation as well, and so that's a hat. I really enjoy doing it, but that's one where I'm wearing a hat that's sometimes out of my comfort zone.
So is that what I was referring to, what I was talking about previously, where sometimes a judge will assign a lawyer to for the best interest of the child?
Absolutely, yeah. So I sometimes explain it as us being sort of a poor man's psychologist in that circumstance, because there's different processes by which you can enter the voice of children into legal proceedings. And I mean, there's been resolutions from the United Nations saying that children's voices are imperative to legal proceedings where decisions are being made about them. There's a process known as, and this is a very unimaginative name, but it's called a Practice Note 7 intervention. And that's where a judge orders people to, engage a psychologist or social worker to any number of processes. One of them is a voice of the child intervention, where through several interviews, they'll sort of be able to report to the court about the children's views and preferences. But there's some interventions where it's therapeutic interventions. They're dealing with family dynamics and working with all the parties in the family. There's psychological assessments that they can do. So when they're directed by the court process, the court first has to be satisfied that the process can be paid for. And so, you can expect a $5,000 to $10,000 retainer with some of the professionals that do these types of processes. And so if there's no ability to afford that, then they'll look and say, well, let's appoint, and sometimes they'll do both. They'll appoint the child a lawyer, and the lawyer will direct, let's use an intervention process through this practice note that the court has given out. But sometimes they'll say, we have no other way to get the voice of the child to the court than to appoint them their own lawyer. And then we can engage in several different types of processes depending on usually the age and maturity of the child, but we can we can be what's called a best interest advocate, where we sort of ascertain their views and preferences, but then what we are looking to accomplish is going to be in their best interest and may not line up with what their views and preferences are. For older children, I'd say once they hit 14 and up, this can be more of an option, which is just advocacy. You get their views and preferences and you go and advocate for them. That the age, I think, is an important one to talk about. So maybe I'll just do a little sidebar here. But there's this rumor that has taken hold and seems to be every parent I talk to thinks that, once my child turns 12, they're able to choose which parent they want to live with, and no one will second guess that. And I hope I can get to enough listeners here to say, please start spreading a different rumor that that's not true, and that it really depends on the maturity of the child. You might have a 17-year-old who, because of their life experience and maybe because of trauma or maybe because of alienation or a gatekeeping parent or any number of things that cause refuse dynamics in children, that they're not mature enough to make that decision about which parent they want to reside with. Mm-hmm. And you might get a 12-year-old who is really mature and can have, maybe their words should have more weight about what their parenting plan looks like. But there's no hard, fast rule saying a kid turns 12 and then they get to call the shots. And I think it's really harmful, sort of societal understanding that's the case. Because so many people have repeated to me that I think that it must be everyone thinks this, but.
Yeah, and I can imagine too, like if there is that rumor out there, then kids are being pressured, they think that this is coming up. Oh, I need to choose, I need to take more responsibility. And if they don't have that capacity, or if you have a parent that is trying to do coercive control and influence that child, come and live with me because they want to spite, the other parent, that would be something that would be so damaging to the child.
100%. I've seen that many, many times, and it's usually accompanied by, come live with me. By the way, you can have a cell phone. I bought you a puppy and a motorcycle and a
pony.
And a pony.
And you get a pony.
Yes, that's right.
A miniature pony.
Yeah.
It's about the size of a dog. Oh, wait, it is a dog.
Thank you, Lisa Simpson.
That's right.
Yeah. So, time for a shameless plug. Tell us about your practice and how people can get in touch with you.
Okay, so the law firm is Hamilton Cahoon. It's two lawyers, myself and Tom Hamilton. I'm the only family law lawyer in the office. Tom does personal injury law. He does some representation of the Director of Child and Family Services too. So any child welfare issues, he's involved in that. And then some real estate law, wills and estates. But I'm the family law guy in the office. We're at 462 4th Street. Our website is hamiltoncahoon.ca, and you can find out how to get all of us there.
Excellent.
Yeah, so I have actually found this conversation very helpful, and I'm hoping that for a lot of people that are listening, it opens their eyes to some of the dynamics, and also to an understanding of a little bit of how the law works in these situations. Because keep in mind that law is trying to create an alignment between ethics that guide the law and people's lives. It's just that not everybody actually holds the same value. So we don't all have the same ethics to connect to.
Mm-hmm. Yeah, and I really appreciate the fact from listening to you, Darren, where it's about where you actually try to not go to court and where that is the last option. Because I think for a lot of people, they'll watch television or they'll go to media and they think that that's exactly what it is, and where that's the nuclear option, and that there's a lot of steps and that you need to be prepared to do that. And it's about having a lawyer that has those ethics and that has your best interests in mind, even if you're not aware of those best interests at the moment.
Fair enough. Yeah. And I hope that if there's a takeaway from this, that unless there are issues in your sort of intimate partner relationship of abuse and family violence, that the best way to resolve them is by working with your ex-partner and finding a way to move past your emotions towards each other and figure out your own solutions.
Yeah. And I got one more question, and then I think it's time that we start to wrap things up.
Absolutely.
So the last question I have, and that is, earlier in the episode, we were talking about it becomes a he said, she said, and I made reference to, well, there's same-sex couples as well. And what I'm interested in is, from a law position, have you seen a dynamic play out at all? Is it the same? Is it different? Is there unique things in terms of same-sex relationships?
Yeah, I think, well, I mean...
Because let's face it, our society's been set up for heterosexual relationships for hundreds of years. And our flexibility in our society now probably takes a long time for law to adapt to that.
Yeah, and I've been involved in a handful of cases involving same-sex couples or trans people. My approach has been is just to treat them the same as anybody else, and the law is blind, and so the law is going to be applied to partners regardless of their sex. I don't have enough experience with it to be able to answer that, I think, adequately. So I apologize for that.
No, that's fine.
No. Hey, we all have limits to our knowledge.
Well, yeah, absolutely. And if in my own experience, I would say I do see some differences when working with a couple that's coming in that are same sex. But can I really quantify it or say exactly what? Because once again, the majority of the people that I have seen have been heterosexual. So
yeah, I did a mediation with a same-sex couple, and I don't know that I could identify, like, their dynamics were unique and interesting, but I don't know. I think every couple's dynamics are unique and interesting, and so I don't know that I could say this was simply a result of them being a same-sex couple, what the difference is or not. I haven't seen enough different of those situations.
Yeah.
All right, so it's time to pull things together, isn't it?
Yeah,
so
it is.
What's your kind of takeaways?
Well, honestly, my takeaway I already mentioned, like, just with the fact with Darren, where, like, he talked about, like, how, like, being a good lawyer is not always about, like, just rushing right to court, but it's about thinking about what your best interests are, and how, really, one thing that I didn't mention before is how the law, like, our society is moving and changing, and it's words on one level it can almost be something very simple, but it can almost be like stones in a pond. It can have a lot of ripple effects that we are just starting to see.
Mm-hmm. And what about you, Darren? What jumps out to you?
Well, I suppose that I should be referring more people to you guys.
Yeah. Oh, and don't forget to work on that self-care, or be mindful of that self-care.
Yes, I've already forgotten.
Shameless plug.
And for me, I think the big picture is, even if someone is in a situation of really serious coercive control, you need to have someone that's going to stand up for you without adding fuel to that fire. I think that's where it comes to for me.
Mm-hmm. Absolutely. So. Excellent point. Do you have, speaking of the very end,
Go ahead.
Yeah. We have some upcoming events here down at the Synergy Center, which Jeremy will now read for those of you in the Medicine Hat area or that want to come travel on down to see us.
Yeah, absolutely. So for listeners that are in other parts of the world, like Vietnam, that's the newest one, by the way. It's probably a long trip.
Mm-hmm.
So,
but if you want to come, I mean, if you've got the frequent flyer miles, and
hey, you're welcome.
Yeah. Well,
so first, I want to let everyone know that we've been joined by a massage therapist, Vicky, and from December 1st through the 22nd, she has a special on right now. Really wanting people to come in and experience the space, experience her skill at what she does, and so for a 60-minute massage, it's $70.
Oh, excellent. You know what? Maybe I'll have to take advantage of that after one of my sessions.
Get the traps softened up.
Get the traps softened up, yeah.
Yeah. And then the stuff that is coming. So let me get to the right date so I'm not telling you stuff that's already over. There is a breath work that's men only on the 19th of November. There is the Public Safety Responders Resiliency Support Group that's on the 1st of December, 2 p.m. a Reiki training level 1 and 2, December 1st through 3rd, fascia releasing session, December 8th at 6:30, and a breathwork soften into the season, December 10th at 10 a.m. to 6 p.m. That seems like it's long.
Yeah, that does.
That's a lot of breathing.
That is a lot of breathing, but we know how important the breath is for life and for your overall mental health. But on that note, I hope that this has been, a breath of fresh air for people and has given them a lot to think of. I'm Trent Akers.
And I'm Jeremy Alcorn.
See you next time.
Thank you for joining us today. We hope that this message has been as meaningful to you as it has been to us. If you're looking for help, you can find us on Facebook at Humanizing Mental Health.